Google versus Oracle case is in an area that we're all familiar with, but maybe Derek, you want to give us a, and we're gonna do away with the formal introductions, but you want to give us, we'll write up something about who we are. It's a podcast. It's not an advertisement. So Derek, do you want to just take do you think you could summarize this case in 3 minutes? And then we can start attacking like, what is the case we're talking about? Can you do that to get us going?
Sure. So we're talking about the Supreme Court ruling in Google versus Oracle. The case relates to copyright, and in particular relates to a fair use defense that was raised by Google in response to a lawsuit filed by Oracle. Oracle is the successor to Sun, and Sun developed the Java programming language. Java programming language is very popular. Google realized as it was developing its platform for smartphones, which is the Android operating system, that it would probably want to use or allow programmers to use Java on the Android system, using the Android operating system. It went to Sun, predecessor to Oracle, for a license. There were, I don't know the details because I wasn't involved with them. The case doesn't talk about all the details. There's negotiations. A license is offered. Ultimately, Google decides we don't want to take the license. But what Google does is it uses some of the code within the Java programming language, which is called declaring code, and it builds its own, they use the expression application programming interface. I have to be honest, it's not what I would call an application programming interface. It's to me, it's the code that you use to make a call within software, but be that as it may. And they build their own software.
Okay.
And then the lawsuit works its way up through the federal courts, ultimately through the Fed Circuit, and then ultimately up to the Supreme Court. And lower courts made a decision and said, what Google did was not fair use. Supreme Court ultimately determined that it was fair use. But
wait a minute. To be fair, at least on that latter point, which
sure.
The lowest court, the district court, thought it was fair use. The district court had no problem with this. It was the federal circuit. So it's not like this is coming out of the blue, but can we just dive straight in? What was that thing just out of curiosity, and this is not, this is a point for discussion. Why wouldn't you call that an API? Because it seemed to me that the code that was copied here was essentially, and there's a bigger issue we ought to get at, but the code that was copied here was the interface to the libraries that we all know are part and parcel of the language itself, which is another issue, but they were the interface to the library. So why wouldn't you want to? And this is not an attack point, but just why not call it an API?
Yeah, and perhaps it's because I have a out of date sort of educational background. But when I was writing code and making a call to libraries, right, I never referred to it as an API. I would just refer to it as that's the code.
Isn't that the point of this damn case? I'm wondering why the case doesn't come out that way. I'm sorry, I'm diving straight into
but that's okay. I'm just telling you. I mean, when I think of an application programming interface, right, I'm typically thinking of something that again, I'm not saying that my use of the terminology could be wrong, but I'm just simply making a call, and whether it's a library or it's my own code, I'm just making a call within the code. So that declaring code is what essentially instructs me as the programmer about how to make that call. It kind of gives me the format as to how those two pieces of code talk to one another. So from that perspective, I guess it is an API, but I usually view an API as a broader piece, sort of a piece of middleware between two pieces of.
Okay, so hold on. Step back. So Sanjay and Stephen, can I keep diving into this and then you guys can take it from there? So here's my question. when you look at, number one, we all agree that this case is not about the copyrightability of the formal Java language. Do we all agree on that?
Well,
I think so.
Well,
so the Supreme Court assumed that it was copyrightable. So yes, technically speaking, that is correct. But they basically they came at it really through the back door almost, right? They said it's copyrightable, but it's a fair use. So yes.
no.
technically
Wait a minute.
correct.
Can we be? I'm sorry. I have the decision up here, and we can bring it up.
Yeah.
My understanding was never at issue here was the question of. Do you guys remember Pascal? That language?
Oh yeah.
Yes, it was a language that I programmed in many years ago.
Yep.
Yeah, we're all pretty old except Steven, who needs some more gray hair. But wait a minute. Do you guys remember that first book? I remember in high school reading this book that clearly was not a computer. It was a book. Remember those things? I'm trying to find one. I don't have any in my office. But it was a book, and it was like a specification of a language. And you could do that, right? You could say a language ought to have this kind of structure. Okay, so, and then it turned out you could read that book, and if you were skilled at what was called compilers back then, you could write a compiler or interpreter to turn into a language that was usable as opposed to a language you read about at night. Okay, so the formal language so when we talk about a computer language like Pascal or Java, we're talking about a set of symbols which tend to look like words, though there are some that are symbols as well, that allow you to, in a formalistic way, specify instructions to get something, a computer usually, to do something. Agreed? Right. And I understood this case was not about the Java written language like you could have written it up on a piece of paper or in a book. We were talking about the API only. So, Sanjay, can you comment on that? I might be right. I have the decision over here.
Well, you're correct, but I mean, so it was about the API, but the case went a little bit further than what you're saying, right? Is that they assumed copyrightability also of the code in the API.
Oh, I don't disagree with that, but I want to make it clear. This is where I wanted to go for a second, and then you guys can attack. I'm saying the case is not about the Java. Actually, because I think what Derek said was directly on point in my mind. The case was not about the Java language. It was not about the specification of the words that should be used to program a computer, not the actual programming by the programmer, but the sort of book statement of, remember the BNF or the Backus-Naur format? Remember that form of how you specify a language? It was not about a written definition of the language. It was about the code you wrote in the API to actually implement specific tasks.
Well, true. I mean, but strictly speaking, the code was about the case was about the code that was copied, right? Which was API code.
It was, but let me get straight to the point because I'm being so slow about it. Derek is directly on point if you ask me. The language, so we all agree the language has some symbols in it like plus signs and minus signs and all that other stuff, which actually, if you look at it, it really functions. You could have instead when you define a language, you could say to people, you are permitted to assign a variable A, the values B plus C, by using the following symbols. A equals an equal sign, B plus C. You could also have a built-in function, and that's what Derek was getting at. You could have a built-in function called add, and that's what you sort of had in assembly language. Essentially I'm just going to say equals again, but A equals add function of B plus C. So you begin to think that there's certain low-level functions that are simply part of the language. And I'll say what Derek was thinking about was the API. When we think about APIs, we think about not things that are built into the language that everybody uses. We think about code or calls you make to use like some other person's language,
Yeah, that's what I typically That's what I typically think about when I hear about an API. And so, I guess the library, I guess it is an API, but I would refer to it more sort of like, again, a method call. And when I look at it, and again, you guys might not agree with me, but that structure, I mean, there's more than one way to do that call. So if you figure out a way to do it and then people learn over time, like that's the way it should be done, to me, that's worthwhile of some protection. See, in other words, So you're like, wait a minute, Derek, you just
Wait,
made a
it goes the
hard
other way. That's backward.
Yeah, so it's right. So you went the opposite direction I thought you were going to go. I actually, as someone who wrote, some code, not a ton of code, but some code, I think of things like that, and I'm like, I've seen it done differently in different languages, so I understand that these calls, if you will, in my mind, are not necessarily like, always dictated by function per se. There is some expression there, and I think it's worthy of copyright.
Sure, but that's a different issue. So do we all agree that okay, so let's go back to, again, Stephen, do you even remember Pascal? You youngster?
I'm not that young. I programmed in BASIC and Pascal and.
Oh, you did?
Yeah.
Okay. So do we agree that the Pascal language definition is not copyrightable? Because apparently the Java language definition was not copyrightable. All that was at issue here was the API, which was to use your phrase from the podcast, which we can't quite figure out if it was ever published or not, was the structure, sequence, and organization of a certain set of calls for getting library functions.
So yes, I mean that's really, particularly if you look at what was published in the Supreme Court case, that's what they focused on.
Okay, Stephen, go ahead, respond. You're stuck.
So one thing that's bothered me about this decision is that Breyer assumes copyrightability. He just says, I'm not going to decide this issue. I'm only going to decide what's necessary to resolve this particular case. And I can just focus on fair use and just kind of hand wave and say, we'll just assume it's copyrightable. Suggesting that declaring code may not be copyrightable. And Justice Thomas takes him to task in the dissent on that point. Yep. And I think there's a really big flaw, because if the declaring code is not copyrightable, if that actually is possible, then how could there be a fair use defense if there was never a copyright to begin with? So I almost feel like the Supreme Court has to take the position that declaring code is copyrightable in order to even reach a fair use defense, because otherwise there's nothing to defend against.
Right.
Well, where do you guys think, Sanjay, where do you think from having read this, and I haven't read it closely enough, maybe you have, if the Supreme Court were to find any declaring code not just copyrightable, which they assumed, but not subject to fair use defense, what would be the fact pattern?
If they were to find it copyrightable but not subject to fair use defense?
Well, they assumed it was copyrightable, and they said, but the declaring code is as used by Google here, was a fair use. Under what circumstance would they not find a fair use?
I mean, you could just alter any one of the four fair use factors which they relied on, right? And so, they said it was transformative because it went from a server or desktop environment into a mobile environment, which is not technically true.
Seems like bullshit, doesn't it?
But if it were a case where it remained on a server or on a desktop, then under their decision, it would likely not be fair use, right?
So by the way, why is that transformative? I've always understood that. I mean, what is that extension of platforms is not wildly transformative, is it?
I don't think it is, but
Derek, thoughts?
Yeah, I mean, I have to admit, I struggled with the analysis of the majority in terms of them making these decisions and say, well, it's transformative because I sort of unlock the creative juices of all these other programmers to build on the new platform. And I guess sort of at 50,000 feet, that's creative or transformative, but it's not, I mean, and fair enough. I mean, software is sort of a different beast from other works of authorship under copyright, and we think of transformative perhaps in different perspectives when we talk about, like, well, I took the painting and I did something with it and I transformed it into something,
into a comedy. I made it into a book or
But here, the transformative nature to me was I thought just sort of purely commercial.
Did any of you know why on that point? Why didn't Java ever go to phones before Google?
Well, I think it did. Nokia's operating system, I believe, had a little Java virtual machine in it at one point. It was Symbian or something like that. Apple doesn't use Java, right? And so it's not an issue there. And so, with Google, it was really, and this comes out, in any of the number of the opinions, right? It comes out that they wanted to leverage the Java programming community, and that's why they copied, right? They wanted it to be familiar and be leveraged, the skills and the experience and knowledge of the worldwide Java programming community to be able to get Android up and going very quickly. Right?
Steven's chomping at the bit.
No, well, no, I mean, following along what Sanjay said, I think one important point of this case is the fact that Java was so ubiquitous and so many people knew it already because it had been around for so long. And Dave, you had asked about a fact pattern that could come out differently. And I can imagine a small company where they developed an API or they had declaring code and they had implementing code, and they're just getting off their feet, and maybe it's a new market, whatever, and then someone just blatantly copies their declaring code and just changes the implementing code. And in that sense, nobody really knew the interface ahead of time, and that's a completely different fact pattern, where I would say it's not a fair use. You're basically killing this small company before they had a chance to get off the ground.
I would agree with that, because that comes back to my point to Derek. I think that so I like Derek's initial observation that based on his and all of our primitive programming skills, it was the code that was copied was essentially almost fundamental, I'm gathering, to the language itself, and that most people wouldn't have thought a lot about. I mean, most coders, while it might have been part of the API, because it was, I'm assuming, part of it because it made calls to the basic library you'd use, that most people would say, yeah, that's just part of the Java language.
I kind of disagree with that.
Oh, go ahead, dive in.
Yeah, go ahead.
I mean, why is any code fundamental to the language? It overlooks the fact that it's purely expression, right? You could have picked some other words and sequence of words and achieved exactly the same function.
Well, it depends on the function, right? I mean, if you're talking low level, like operating system functions, like schedulers and threads and thread managers and process management, that type of stuff, it's not as transparent.
Well, but I mean, keep in mind there was 11,500 lines of code copied here, right? This was not a few dozen basic words or operations. It wasn't add, subtract, load, store type of stuff like that, right? And so you could have easily come up with different names for these.
Wait a minute. So Sanjay, that's an interesting comment. And this is really cool.
Yeah.
Do you agree? So it goes back. Do you agree that we're not talking about the copyrightability of the language definition? That was never at issue here.
That was not an issue, but I was just disagreeing with your characterization that it had to be that way. It didn't have to be that way. I mean, and that goes to the heart of the expressive nature of it.
No,
it didn't have to be that way. It could have been something else. Right?
That's bullshit, because if you think back to the definition of Pascal, there were, by the time they wrote Pascal, there must have been hundreds of programming languages, all that effectively achieve the same thing. And so we know there's at least 100 ways to express the same basic operation. That's
not the facts of this case. This was not about the copying of the Java programming language. This was the copying of these certain of these APIs. And also they didn't copy every single API. There were only certain ones that they felt that they needed to copy.
No. The ones they need to copy, they're the ones that Derek was getting at, the ones that were part of the language, because it turned out that you could, if you ask me, when you define a language, you have a choice of using symbology, symbols like plus signs, minus signs, pointers, and everything else to allow the programmer to express operations to be formed. You have an alternative. As an alternative, you can use words and function calls. So when you write a language and define a language, you have a choice of saying, boy, when we want an add function done, we're going to require that the programmer use variable name equal sign, variable name, plus sign, variable name. But you could alternatively say to the programmer, if you want an ad done, put down variable name, equal sign, the phrase add, an open parentheses, a list of variables, and a closed parentheses. So there's a millions of ways to do that, but in point of fact, there's really no difference between the symbols and the words that are the function calls.
So, but one thing, let's be clear about this. This is not a case about compatibility, right? So they actually had their own Java virtual machine. They changed a bunch of aspects about it. It's a case about familiarity by programmers.
But that's the point, is it not the case that I keep thinking of the analogy in trademark law, which is that is it Saran or what's the word? Remember, you used to the stuff that
Saran wrap, aspirin, what? So
yeah.
Something becomes familiar, you lose rights in it?
Exactly. So in this case, the analogy in copyright law was the damn functions, which could have been turned into symbols, and we all would have said they were simply part of the language definition, have simply become part of the language. And you can't define Java anymore without, 37, Sanjay? 37 basic functions. Whatever the number is.
Yeah, but that's going beyond the facts of this case, though, right? I mean, if you actually look at what was copied, there's no reason there's no technical reason to have to use that same expression.
Yeah. Because de facto, it became part of the language. Did it not become part of the language de facto, like Saran wrap and aspirin and all those other things? I know those are trademark law, different issue, but the law is the law.
If I understand Sanjay correctly, I mean, I think the particular functions that were copied here are probably not the most essential. And what I was trying to say earlier with like an operating system, there are functions that are truly essential and really go to the heart of the operation of something.
We know what
but see, that's not what happened here, right?
Right.
They created a new Java within Android. They changed a whole bunch of it and copied some of it, which means that they could have changed all of it.
No, but de facto, do you agree?
They chose not to. It was a decision that they made. They could have changed it all. They had a choice to not copy.
No. Do you agree that de facto, and this is part of the case, I think, they had to copy the ones that were necessary?
No, they did not. That's not part of the case at all.
The
only reason they copied was programmer familiarity.
That's the point.
No, it's not the
That's
point.
the
If they
point.
did not copy, they would have had to spend large sums of money retraining programmers.
Exactly. So right. So let's take that to the logical extreme. They could have come up with a completely new language, and then that would have really, really solved your problem. I'm saying that this thing became a freaking. So Java was in the not public domain, but Java for some reason is assumed to be a method or a business. As the Java definition does not form part of copyrightable domain, and through use of these, I'm going to call them fundamental functions. Stephen seems to say they're not the operating system ones, but they must be critical ones. Otherwise, we wouldn't have taken them. They de facto became part of the structure, and you would have had to retrain people if you wanted to go.
But what you're saying though is if true, that the decision should have been based on different rationale, not on fair use.
Well, I think that I think I have the decision in front of me. Number one, quickly, there were 3 factors they went on, and I did highlight them. So I'm just going to remind you guys because I have it on this other machine here. One was the nature of the copyrighted work, which seemed kind of like bullshit. One of them was the purpose and character of use. That's the transformative piece, which do we all agree that was complete garbage? The transformative use?
I do.
By the way, I like beer, so I'm not against the Supreme Court. I just happen not to like that. And the final one was okay. The amount and substantiality did seem like a small portion. You guys comfortable with that?
I mean, see okay. So I have a function or a method, right? And the method is supposed to return, an ordered list. So I pass to the method a bunch of data, and I say return back the list in alphabetical order. But the declaring code or the calling code is what was copied, right? And to me, again, if I'm writing a programming language, I can tell you that the declaring code in Java looks different from the declaring code in C++, looks different from the declaring code in other programming languages. So to me, there's plenty of different ways to express the similar concept. So I think we should protect the expressions.
Okay, then why didn't you protect the Java language itself? Why was that not on the chopping block?
That's where, you know, the whole characterization of it being an API kind of, I think, maybe changed the direction of the case. I'm not sure, because again, I wasn't deeply involved in the initial sort of, you know, lower level court rulings and filings, etc. But that's, you know, that we're all along talking about an API, but then as I look at least the way the Supreme Court decision came out, I was like, oh, that's actually, like, to me, fundamental pieces of the programming language. And I would say that the language, because there's so many different languages out there, I would say that language is entitled to copyright protection, because you can essentially achieve the same function with another language.
Okay, so maybe there's the facts in it. So somebody here may be old enough to remember this. Was Java, when it was part of, who was it? Sun?
Sun, yeah.
Did Sun just dedicate that language to the public? Do you guys remember?
I mean, not that I'm aware of.
It's always been licensed. I mean, some of the licenses are relatively permissive, but it's always been licensed.
So let me read you this quote again. I'm staring over here.
Go ahead.
Green. Okay, this is from the opinion, the majority opinion. This is the discussion of fair use, and what do you say is Breyer? Okay, the declaring, and this is from page 22 of the downloaded version. The declaring code at issue here resembles other copyrighted works in that it is part of a computer program. They go on, Congress has specified that computer programs are subjects of copyright. Okay, here we go. And I highlighted in red. It differs, however, the declaring code differs, however, from many other kinds of copyrightable computer code. It is inextricably bound together with a general system, the division of computing tasks that no one claims is a proper subject of copyright. So wait a minute, so we're in a fair use discussion, but now we're being told, well, it's copyrightable, but it really isn't, so we'll call it a fair use. So respond to that? Oh, well, but I still like what Stephen said a bit ago, which is I'm actually totally with Stephen, that if it weren't, my theory would be, if this hadn't become de facto by the Saran Wrap doctrine, the analogous Saran Wrap doctrine, if it hadn't become de facto part of the language and instead was the result of a new company's work, that probably wouldn't be the case.
Yeah.
Well, so
your point, Stephen, go.
I don't know if that sentence is actually fair, given that one of the questions presented was whether the code was whether declaring code is copyrightable, and for the majority to say no one claims it's a proper subject of copyright seems inconsistent with the question presented. But aside from that, I mean, I agree with Derek, just for what it's worth. I mean, I view this more like a database schema. I mean, the way you organize things, the way you structure things has an expressive element to it.
Yeah.
But wait a minute.
I agree with that too. It had that level of organization to it. Yeah.
But not all expressive things are copyrightable, correct?
Sure.
I mean, there's something about functionality, and again, I've forgotten where Saran Wrap plays into. Again, it's trademark law, but I'm not forgotten where that plays into the copyright side. But aren't there some basic statements of, is it section 101 that essentially says to you that if this is fully functional, it's not the subject of copyright, or was that the Mazer v. Stein, or was that what do you call that? What was the Baker versus Selden? Remember that with what is that? The accounting system?
yeah, no, I mean, you're right in the sense that copyright law clearly says that, you know, functional items are not copyrightable, right? And there always is going to be a challenge with respect to software because it ultimately does do something functional. I mean, right? And so, you know, if you go back to the various copyright cases, and you look at the Altai case, right, where we've had the first case that makes the decision about.
Is that the gaming case way back when?
I think is it Computer Associates versus Altai, which is a case back in the 90s, right? Which was, I think, the first
Before
case.
Stephen was born.
I think that's the first case that says, well, look, we're dealing with software and we have to figure out, okay, what portions of the code really are related to functional features or aspects, and maybe they're not entitled to protection, but what
Right, the abstraction test.
Right?
Yeah.
Are not functional. And so we're going to separate out the two, and then we're going to do the comparison, right? We're going to do the right and see what people have come up with. And again, what I would go back to, and again, maybe my thought process is outdated or outmoded, but if you go to a university today and you go to CS 101 and you have, I don't know, whether it's 30 students in the class or 300, and the professor says, I want you all to write a piece of program, or I want you to write a program that does X, Y, and Z. I suspect that he's saying I'm going to have 30 or 300 different expressions, even if they're all written in the same programming language, right?
Yeah.
And they all have so is the copyright protections thin for software?
Yeah, so super narrow, and that's super narrow.
I mean, it is thin, but I think it is there, and I guess when I look at this in terms of the way that Java is set up, I just look at it and I say, okay, here's the method call, here's the declaring code. I just see other languages that have done it differently, so to me, it's protectable.
Okay, so I'm going to go the other way on this, which is I'll completely agree. I like where you're going with that story. So we'll say it's super thin, and maybe in this case, when you combine the super thin protection that this expression is entitled to, the copying was so relatively de minimis, it just wasn't worth making it actionable.
Right. I mean, perhaps that would have been the better analysis. To me, it just seems the thing that kind of struck me that seemed a little bit distorted in the Supreme Court's opinion. Well, maybe two things. One was sort of the commercial nature, and then again the thing that really kind of I did not buy into, which was, well, it's a transformative use. Because to me, it's just a commercial use, right?
In that sense, I think the Federal Circuit's opinion is a bit more intellectually honest. They acknowledge that it was, there are some close things here and there, and then ruled in favor of Oracle, whereas the Supreme Court kind of found it necessary to stretch every which way they could to find all four factors in favor of Google.
Right. This is what's so both irritating and great about the law, right? Okay, so I don't know. This I think we're at the end of this thing. You said, did any of you read the dissent? By the way, can you comment on that? Because the majority, I did not. Did the majority's comment on the dissent was that Thomas basically, according to the majority, said that fair use has no application in software. Did Thomas really say that? Sounds like a no.
No, I think one of the points that Thomas brings up is he says, well, look, you didn't really go through the copyrightability. You didn't tell me explicitly how much protection is this code entitled to, right? So getting back to the thin copyright, and so that's one of the criticisms that Thomas levies, is he just says, well, you skipped over the copyrightability question, and therefore your fair use analysis is distorted.
Okay, let me read this. Hold on, before you say that, because you might have read it. I'm reading from the majority opinion.
Yeah.
Justice Thomas's thoughtful dissent offers a very different view of how, and perhaps whether, fair use has any role to play for computer programs. We are told, presumably by Thomas, that no attempt to distinguish among computer code is tenable when considering the nature of the work, even though there are important distinctions in the ways the programs are used and designed. We are told that no reuse of code in a new program will ever have a valid purpose and character, even though the reasons for copying computer code may vary and differ from those applicable to other sorts of works. Blah, 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 blah. And we are told that our fair use analysis must prioritize certain factors over others. So was Thomas that hardcore? Because they seem to be boxing him in. Oh, Stephen's saying no.
Go ahead, Steve.
I don't remember all the details, but I think some of the statements you just read seem a little on the extreme side. I think Thomas said that there was no fair use in this case. I don't know if he said ever, the way some of those statements read.
One of the things that I find a bit challenging, right, again, is I look at that and they say, well, we're going to look at software, and software compared, again, to other works of authorship, the copyright protection afforded to software is relatively thin. And then if you were to follow the Supreme Court's rationale a little bit further, they can say, well, then there's different categories of software. There's APIs versus this type of software versus this type of software versus this type of software. And to me, I don't know if I want to go down that hole to say, well, there's 500 different types of software and one type is entitled to more protection. It's still thin, but more protection than this other type of software.
So, Greg, Sanjay.
Yeah, and Derek, you had raised another point which you had raised earlier when we first started talking about this, was that Justice Thomas is the one who authored the Atlas opinion on the Section 101 eligibility and patents.
Yep. And the reason why that's kind of interesting is because when you talk in general about how you're going to protect some computer innovation or software innovation, right? You assume that the code that you write has at least some copyright protection. If you write code, right, develop a software innovation, then there's the potential of getting a patent on it as well. But software implemented or computer implemented inventions are attacked, from 9 different directions when we go down the patent path, including sort of the latest case, which is Apple v. U, which was directed to a camera, but they say there's some functional language in there about what the processor does, and we think that's abstract. I mean, to me, that case is sort of at the extreme. We'll see where it goes. But so you have this challenge of, well, how do I protect software? On the one hand, we said way back when, going back to the when the copyright law was changed in the 70s, to say, well, software is copyrightable, right? Originally, right? When we go back to those hearings. And then we say, yes, you can get a patent on it. And from an engineering perspective, you look at software. Well, what is it? It's sort of a replacement for hardware, right? But in functional ways, in many ways, it does the same thing.
Or you can look, or hardware is a primitive version of software.
Or hardware is a primitive version, yes. But I mean, but now we look at it and we say, well, oh boy, if we try to patent it, we're often going to run into issues that it's abstract, and then if we try to protect it by copyright, we're not going to have protection.
It's an unclean world, and isn't the answer, and what's good for us as lawyers, is that you should do all these things to the extent you can. To the extent, for example, we haven't talked about trade secrets, and we all know that trade secret protection and patent protection can be antithetical. Sometimes they can go along together, but not comfortably, and only after severe review. But isn't the answer, Derek, on that particular point, look, don't put all your eggs in one basket. Sure, try to patent some pieces of it if you can. Hope that your copyright works on other pieces of it. If there's an area where trade secret would weigh in, and you have to be careful about that, try to use that as well. And I guess we haven't talked about trademarks, but you could argue being the first mover or the significant player whose trademark makes sense. So isn't that it's sort of the answer?
I mean, I think it is the answer, but I do think that I think some of the stakeholders are really going to have to look at some of this and make a decision about, is there something that needs to be done on a legislative basis to maybe look at this again? Personally, I look at it and I say, if I'm in the business of, I want to create innovations and I'm going to make my revenue by selling those innovations as opposed to, for example, selling ads, I'm in a heck of a bind in terms of trying to protect some of these technologies.
I disagree. I'll argue that that's very okay. So perhaps so. But that's because the law is not rigid, and the very thing you're worrying about, when you put yourself in that role, the very thing you're worrying about is probably also the thing that helped you get where you are today. In point of fact, the law is gray in many areas, and that's why we can all push our companies, to take your analogy, we can all push our companies forward in various ways. There's pretty clearly things we can't do. If there's a technology out there that's patented and the patent's been litigated and won 50 times, probably not a good thing to copy. On the other hand, if you've got an API that has de facto become part of the programming language, then that's probably safer grounds to copy.
Yeah, I mean, clearly under the Supreme Court's ruling, I agree with you.
So I want to go and see. So Stephen, in a version of this podcast, the 5-minute version, and it was probably chopped out in order to make it 5 minutes. I think you said something about, we talked about what this case stood for. You remember that? Remember you made some comment about what this case stands for? And I think it does stand for what you just said a bit ago, which is this case stands for the proposition that APIs, remember this, you said APIs can be protectable, but not always. You remember, does that ring a bell? Because I'm going to say the two directions are, if it's a new API in a new area and it's not de facto part of the programming language and necessary for programmers to, practically speaking, use the language, then it may be. If it's not part of that, it may be protectable. On the other hand, if it's de facto been subsumed into the language, then it's probably not protectable. Is that fair, or are you guys going to resist that?
I don't remember what I said exactly, but I do think that it's going to be very fact dependent, in my personal opinion. I think when something does become like a de facto standard, maybe generic as you're analogizing to trademarks, maybe you get more like this Google case. But in other cases where, there's more upstart technologies or companies, I think that it's got to be more protectable, in my opinion.
Can you live with that, Derek, based on your hypothetical, sort of putting yourself in the shoes of not the developer, I think it's the CEO, but.
Sure. I mean, I think your analogy is a creative one, but I don't know that I'm ready to apply that principle to copyright law. In other words, I get a little concerned that because my language is popular, that I've all of a sudden lost rights in it.
Sanjay, can you bring?
Well,
yeah,
that's absolutely right. I mean, if you have a business model where you want to develop some new type of programming language or new environment and go out and license that, I think in view of this case, that's the viability of that business model is seriously questioned.
Thank you, gentlemen.
Thank you, David. Appreciate it.
Thanks, David.
Good discussion.
Bye-bye.
Thanks, David.
Bye-bye.